Please be seated. The sitting is open. The court meets today and will meet tomorrow under Article 74, Paragraph 3 of the Rules of Court to hear the oral observations of the parties on the request for the indication of provisional measures submitted by the Republic of Armenia in the case concerning application of the International Convention on the Elimination of All Forms of Racial Discrimination, Armenia versus Azerbaijan. This morning, the court will hear Armenia's first round of oral argument. Owing to the ongoing concerns and restrictions related to the COVID-19 pandemic, the court has decided to hold these oral proceedings in a hybrid format under Article 59, Paragraph 2 of its rules. The court will continue to fulfill its mission through all means at its disposal, pending the normalization of the health situation. The court has taken great care to ensure the smooth conduct of this hybrid hearing. The parties participated in technical tests prior to the opening of the hearing. The tests were comprehensive and included, for example, tests of the interpretation system and the process for displaying exhibits. However, while these tests reduce the risk of technical difficulties, they cannot eliminate them. In the event that we experience any such difficulty, such as the loss of audio input from a remote participant, I may have to interrupt the hearing briefly to allow the technical team to solve the problem. In a hybrid hearing such as this one, all judges are able to view the speaker and any exhibits, regardless of whether they are in the Great Hall of Justice or joining via video link. I would like to note that the following judges are present with me in the Great Hall of Justice: Vice President Gevorgian and Judges Tomka, Yusuf, Shway, Sebutinde, Iwasawa, and Nolte, and Judge Ad hoc Doday, while Judges Abraham, Benuna, Bandari, Robinson, and Salam, and Judge Ad hoc Keith are participating by video link. For reasons duly made known to me, Judge Cansado Trindade is unable to sit with us in these oral proceedings, either in person or by video link. For this set of hybrid hearings, the parties were informed that they could each have up to 4 representatives present in the Great Hall of Justice at any one time, and that the court would make available, should a party so desire, an additional room in the Peace Palace from which other members of each delegation could follow the proceedings via video link. The parties were also informed that participation by video link would be available to members of each delegation who would not be present in the Peace Palace. The court does not include upon the bench a judge of the nationality of either of the parties. Accordingly, both parties have availed themselves of the right, under Article 31, Paragraph 3 of the statute, to choose a judge ad hoc to sit in the case. Armenia has chosen Professor Yves Doday, and Azerbaijan, Judge Kenneth Keith. Article 20 of the statute provides that every member of the court shall, before taking up his duties, make a solemn declaration in open court that he will exercise his powers impartially and conscientiously. Pursuant to Article 31, Paragraph 6 of the statute, the same provision applies to judges ad hoc. In accordance with custom, I shall first say a few words about the career and qualifications of each judge ad hoc, before inviting them to make their solemn declarations. Judge Kenneth Keith, who is a national of New Zealand, studied law at the University of Auckland, Victoria University of Wellington, and the University of Harvard. He was a member of this court for 9 years, from 2006 to 2015. His wide-ranging and illustrious career in the legal field includes vast experience as an academic, government lawyer, and judge. Judge Keith is a professor emeritus at the Victoria University of Wellington, where he taught for more than 20 years, and a member of the Institut de Droit International. He was a member of the New Zealand legal team in the nuclear test cases before the International Court of Justice in 1973, 1974, and 1995, and was leader of the New Zealand delegation to the diplomatic conference which prepared the additional protocols to the Geneva Convention in 1977. He served in the New Zealand Department of External Affairs as director of the New Zealand Institute of International Affairs and as president of the New Zealand Law Commission. Judge Keith also served as judge of the New Zealand Court of Appeal of the newly established Supreme Court of New Zealand, and at various times as judge of appeal in Samoa, the Cook Islands, Niue, and Fiji. He was also a member of the Judicial Committee of the Privy Council, London. I shall now say a few words about the career and qualifications of Professor Doday. Professor Doday, who is of French nationality, is a Doctor of Law and Professor agrégé in Public Law and Political Science. He is currently President of the Curatorium of the Hague Academy of International Law and Emeritus Professor at the University of Paris I, Panthéon-Sorbonne, where he served as first Vice President. Professor Doday is an arbitrator in the Court of Conciliation and Arbitration within the Organization for Security and Cooperation in Europe. He has held a number of academic and research posts in France, Mauritius, Morocco, and Côte d'Ivoire. He was a member of the French delegation to the United Nations Conference on an International Code of Conduct on the Transfer of Technology. He has been chosen as a judge ad hoc on numerous occasions and is currently sitting in the cases concerning armed activities on the territory of the Congo, Democratic Republic of Congo versus Uganda, alleged violations of sovereign rights and maritime spaces in the Caribbean Sea, Nicaragua versus Colombia, and dispute over the status and use of waters of the Silala, Chile versus Bolivia. He also recently served as a judge ad hoc in the case concerning application of the International Convention on the Elimination of All Forms of Racial Discrimination, Qatar versus United Arab Emirates, and in the two cases concerning appeals relating to the jurisdiction of the ICAO Council, among others. Professor Doday is a member of the editorial board of the Annuaire François de Droit International and is a member of the French Society of International Law and the French branch of the International Law Association. He has published numerous books and articles in different areas of international law. In accordance with the order of precedence fixed by Article 7, Paragraph 3 of the Rules of Court, I shall first invite Judge Keith to make the solemn declaration prescribed by the statute, and I would request all those present to rise. Judge Keith, you have the floor.
Thank you, Madam President. I solemnly declare that I will perform my duties and exercise my powers as judge honourably, faithfully, and conscientiously. Thank you.
I thank you, Judge Keith. I now invite Professor Doday to make the solemn declaration prescribed by the statute. Professor Doday, you have the floor.
Merci.
Thank you, Madam President. I solemnly declare that I will perform my duties and exercise my powers as judge honourably, faithfully, impartially, and conscientiously.
I thank you, Professor Doday. Please be seated. I take note of the solemn declarations made by Judge Ad hoc Keith and Judge Ad hoc Doday and declare them duly installed as judges ad hoc in the case concerning application of the International Convention on the Elimination of All Forms of Racial Discrimination, Armenia versus Azerbaijan. I shall now recall the principal steps of procedure in the present case. On 16 September 2021, the Republic of Armenia filed in the Registry of the Court an application instituting proceedings against the Republic of Azerbaijan concerning alleged violations of the International Convention on the Elimination of All Forms of Racial Discrimination. I shall refer to this convention as CERD. To found the jurisdiction of the court, Armenia invokes Article 36, Paragraph 1 of the Statute of the Court and Article 22 of CERD. In its application, Armenia contends that for decades, Azerbaijan has subjected individuals of Armenian ethnic or national origin to racial discrimination in furtherance of, I quote, its policy of cleansing Azerbaijan and Nagorno-Karabakh of Armenians and Armenian influence, end of quote. Armenia claims that Azerbaijan has committed serious violations of Articles 2, 3, 4, 5, 6, and 7 of CERD, including but not limited to what it describes as engaging in practices of ethnic cleansing, glorifying, rewarding, and condoning acts of racism, facilitating, tolerating, and failing to punish and prevent hate speech, depriving Armenians of the equal enjoyment of their individual rights, and systematically destroying and falsifying Armenian cultural sites and heritage. Armenia alleges that all good faith efforts on its part to put an end to these violations through other means have failed, and thus requests the court to hold Azerbaijan responsible for its violations of CERD, to prevent future harm, and to redress the harm that has already been caused. Together with its application, Armenia also submitted a request for the indication of provisional measures, referring to Article 41 of the statute and Articles 73, 74, and 75 of the Rules of Court. According to Armenia, the purpose of its request is to, I quote, protect and preserve Armenia's rights and the rights of Armenians from further harm, and to prevent the aggravation or extension of this dispute, pending the determination of the merits of the issues raised in the application. End of quote. The registrar will now read out the passage from the request specifying the provisional measures which the government of Armenia is asking the court to indicate. You have the floor, Mr. Registrar.
Thank you, Madam President. I quote, Azerbaijan shall release immediately all Armenian prisoners of war, hostages and other detainees in its custody who were made captive during the September-November 2020 armed hostilities or their aftermath. Pending their release, Azerbaijan shall treat all Armenian prisoners of war, hostages and other detainees in its custody in accordance with its obligations under the CERD, including with respect to their right to security of person and protection by the state against all bodily harm, and permit independent medical and psychological evaluations for that purpose. Azerbaijan shall refrain from espousing hatred of people of Armenian ethnic or national origin, including by closing or suspending the activities of the Military Trophies Park. Azerbaijan shall protect the right to access and enjoy Armenian historic, cultural and religious heritage, including but not limited to churches, cathedrals, places of worship, monuments, landmarks, cemeteries, and other buildings and artifacts, by inter alia, terminating, preventing, prohibiting, and punishing their vandalization, destruction, or alteration, and allowing Armenians to visit places of worship. Azerbaijan shall facilitate and refrain from placing any impediment on efforts to protect and preserve Armenian historic, cultural and religious heritage, including but not limited to churches, cathedral, places of worship, monuments, landmarks, cemeteries, and other buildings and artifacts relevant to the exercise of rights under the CERD. Azerbaijan shall take effective measures to prevent the destruction and ensure the preservation of evidence related to allegations of acts within the scope of the CERD. Azerbaijan shall not take any action and shall assure that no action is taken which may aggravate or extend the existing dispute that is the subject of the application or render it more difficult to resolve, and Azerbaijan shall provide a report to the court on all measures taken to give effect to its order indicating provisional measures no later than 3 months from its issuance, and shall report thereafter to the court every 6 months. End of quote. Thank you, Madam President.
I thank the registrar. Immediately after the application and the request for indication of provisional measures were filed, the registrar transmitted certified copies thereof to the government of Azerbaijan. He also notified the Secretary General of the United Nations. According to Article 74, Paragraph 1 of the Rules of Court, a request for the indication of provisional measures shall have priority over all other cases. Paragraph 2 of the same provision states that the court shall proceed to a decision on the request as a matter of urgency. This imperative must, however, be balanced with the need to fix the date of oral proceedings in such a way as to afford the parties an opportunity to be represented at the hearings. Consequently, the parties were informed that the date for the opening of the oral proceedings, during which they could present their observations on the request for indications of provisional measures, had been fixed for Thursday, 14 October at 10 a.m. I would now like to welcome the delegations of the parties. The agent of Armenia is present in the Great Hall of Justice, and the agent of Azerbaijan joins us by video link. The agents are accompanied by members of their respective states' delegations, some of whom are physically present in the Great Hall of Justice, while others are participating in the hearings remotely. For the purposes of this first round of oral argument, each of the parties will have available to it a 2-hour sitting. The court will hear the oral argument of Armenia, which has submitted the request, this morning until 12 noon. It will then hear the first round of oral argument of Azerbaijan this afternoon between 4 p.m. and 6 p.m. The parties will then have a possibility to reply. Armenia will have the floor again tomorrow, Friday, 15 October at 10 a.m., and Azerbaijan will take the floor in turn on the same day at 5 p.m. Each of the parties will have a maximum time of 1 hour in which to present its reply. In this first sitting, Armenia may, if required, avail itself of a short extension beyond 12 noon today, in view of the time taken up by these introductory remarks. Before giving the floor to the agent of Armenia, I wish to draw the attention of the parties to Practice Direction 11, which states as follows. In the oral pleadings on requests for the indication of provisional measures, parties should limit themselves to what is relevant to the criteria for the indication of provisional measures, as stipulated in the statute, rules, and jurisprudence of the court. They should not enter into the merits of the case beyond what is strictly necessary for that purpose. I now give the floor to the agent of Armenia, His Excellency, Mr. Yagishi Kirakosyan. You have the floor, sir.
Thank you. Madam President, distinguished members of the court, it is a great privilege to appear before you today as the agent of the Republic of Armenia. In these proceedings instituted before the court on 16 September 2021, Armenia does not ask the court to resolve all of the many issues that have long divided the parties to this case. Much less does it ask the court to reverse of all of the many consequences of the most recent armed conflict. With its application, Armenia instead seeks to prevent and remedy the cycle of violence and hatred perpetrated against ethnic Armenians. And with its request for provisional measures, Armenia urgently seeks to protect the rights of ethnic Armenians from imminent and irreparable harm. Both Armenia's application and request for provisional measures are grounded in the International Convention on the Elimination of All Forms of Racial Discrimination. The Convention reaffirms in its 7th preambular paragraph that, I quote, "Discrimination between human beings on grounds of race, color, or ethnic origin is an obstacle to friendly and peaceful relations among nations, and is capable of disturbing peace and security among peoples and harmony of persons living side by side." These proceedings have been motivated by these words, and they are of utmost importance to my country. It is uncontroversial that Armenians are a distinct ethnic group, and as such are protected by the Convention. Armenians have historically inhabited a region in the Near East bounded by the Mediterranean and the Black Seas and the Caucasus. Armenian history can be traced back thousands of years, more precisely to the 2nd millennium BC. Almost all Armenians are Christians, and the Armenian Apostolic Church is the oldest Christian church in the world. The Armenian language is an independent branch of the Indo-European language family and uses its own unique alphabet since 405 AD. Because of their distinct ethnic identity, Armenians have experienced ethnic hatred and countless persecutions. They have also been subjected to genocidal massacres and pogroms. Sadly, the experience continues to this day. The international armed conflict, which President Aliyev has openly admitted Azerbaijan started in September 2020, is the most recent link to this chain of ethnic violence and hate. We fear that it will not be lost unless the roots of this conflict are addressed. The ethnic hatred that Azerbaijan's authorities spew almost on a daily basis is so pervasive that nearly all of the Azerbaijani society is affected. Generations upon generations are indoctrinated into this culture of fear and hate of anything and everything Armenian. Murder, torture, and other inhuman and degrading treatment of ethnic Armenians who find themselves under the authority of Azerbaijan are systematic, as is the reward and even glorification of the culprits, and prosecution of anyone who dares to contradict the official dogma. Every trace of Armenian presence in the region must be destroyed or otherwise erased or falsified. This is clear from the fact that not even the conclusion of the trilateral statement of November 2020 has prevented Azerbaijan from violating the convention. Azerbaijan continues to espouse and actively promote ethnic hatred against Armenians. The so-called military trophies park, erected in April this year, while Azerbaijan was professing to negotiate its violations of the convention in good faith, has stood as a grotesque monument to this ideology of hate. Azerbaijan has captured, tortured, and arbitrarily detained numerous members of Armenian armed forces and civilians of ethnic Armenian origin. Azerbaijan, moreover, continues to destroy Armenian cultural heritage and religious sites or negate their Armenian character in the territories it now controls. All those grave violations were perpetrated and continue to be perpetrated as we speak, precisely because their perpetrators have been enabled, encouraged, oftentimes rewarded, even glorified by Azerbaijan through systematic discriminations against Armenians. Madam President, distinguished members of the court, I do not intend to burden you with political statements about how the events that have ravaged my region of the world for more than a century now came to bear. Such statements have little relevance in the court of law, especially under the current urgent circumstances. But I do wish to underscore that the case Armenia brought to the court after nearly 1 year of failed negotiations, notwithstanding the urgent circumstances motivating the present request, falls squarely within your jurisdiction under the CERD. The plausibility of the CERD rights at issue and the urgent need for you to order measures to protect those rights from irreparable harm pending judgment on the merits are also obvious, as our counsels will explain in detail. First, Professor Kolb will explain why the court has prima facie jurisdiction to entertain Armenia's request. Second, Dr. Salonidis will demonstrate the plausibility of rights under the CERD for persons of Armenian ethnic origin to be free from hate speech by Azerbaijan, including their physical manifestation in the so-called military trophies park. Third, Professor Murphy will then demonstrate the plausibility of rights under the third for prisoners of war and civilian detainees of Armenian origin to be repatriated and to be protected from inhuman treatment. Fourth, Professor Darjan will demonstrate the plausibility of rights under the third for persons of Armenian origin to access and enjoy their cultural heritage, and Azerbaijan's corresponding obligations not to destroy, erase, or falsify it. Mr. Martin will conclude Armenia's presentation by explaining why there is a real and imminent risk of irreparable prejudice to the rights whose protection is sought, as well as the link to specific measures requested. The importance of your decision on provisional measures and the impact that such decision will have cannot be emphasized enough. Azerbaijan's systematic continued violations of the third by exhortation of ethnic hatred in all the aforementioned forms stand as an insurmountable obstacle in a way of ensuring peace and security in the region. I thank you, Madam President, distinguished members of the Court, for your attention and for your careful consideration of Armenia's request. I now kindly ask that you invite Professor Kolb to address the Court. Thank you.
I thank the agent of Armenia for his statement, and I now invite Professor Robert Kolb to take the floor. You have the floor, Professor.
Je m'exprimerai en français.
I shall be speaking French, Madam President. Madam President, distinguished members of the Court, it is my task today to talk to you about your jurisdiction in provisional measures cases. I am very happy to not have to weigh your spirit down with convoluted explanations or extend our debate by repetitions, rehearsals and reminders full of agreeable veneration. My presentation will be brief. Why? Well, because your jurisdiction is easy to demonstrate, and all the more so given the prima facie blueprint to which it is subjected. Furthermore, this stage, this preliminary stage, requires clear and linear responses which are brief and incisive. So we can attempt to look at this in a calm spirit. The Court has asserted on numerous occasions that the Court need not satisfy itself in a definitive measure that it has jurisdiction as regards the merits of the case. It is sufficient for the Court to conclude if the provisions relied on by the applicant appear prima facie to afford a basis on which its jurisdiction could be founded. Now, the basis for jurisdiction adduced by Armenia is the compromissory clause contained in Article 22 of the 1965 Third Convention. Both of the parties acceded to the convention without reservation. The jurisdictional conditions, thus, of Article 22 are met. Let's have a look at that more closely. A dispute with respect to the application of the Convention? Well, of course. Correspondence between the parties in the Court's possession both attests and confirms it. Armenia alleged by its letter of 11 November 2020 that Azerbaijan had breached and continued to breach different obligations of the Convention. In its reply of 8 December 2020, Azerbaijan disputed being responsible for such breaches. The respective letters of the parties can be found in the annexes of Armenia's application, and their exchange unequivocally demonstrates the existence of the dispute. Failed negotiations? Well, assuredly. Your court has felt that a negotiation precondition was satisfied when the parties' basic positions had not subsequently evolved after several exchanges of diplomatic correspondence and/or meetings. Now, in the instant case, the parties have had 40 exchanges of correspondence. They met up 8 times. And the parties have exchanged their views in a number of ways. But no agreement came about. Azerbaijan's positions on Armenia's claims have not varied. They remained negative. And the position of Armenia hasn't changed during these lengthy exchanges. In its letter of 11 November 2020, then in the standpoint it expressed on 31 May 2021 relative to the subject matter of negotiations, and once again in the meetings of 15 through 16 July 2021, and no less in the meetings of 14 through 15 September 2021, Armenia has asserted and argued one thing and one thing alone. What? Well, that Azerbaijan has breached and continues to breach Articles 2 to 7 of the 1965 Convention. Now, what has Azerbaijan done? Well, they have consistently and constantly denied these breaches. Its letter of 8 December 2020, and then Azerbaijan's replies during the negotiations 31 August 2021, and the allegations in a number of its letters bear eloquent witness to this. Subsequently, the parties' positions have not evolved. Do we need further proof? Well, if we do, here it is. Armenia laid claim to certain remedies with respect to violations of the 1965 Convention. Azerbaijan then rejected them wholesale during the meetings of 30 through 31st of August. Azerbaijan preferred to formulate a slew of counter-proposals, and at the same time, Azerbaijan defended itself from having committed acts contrary to the Convention. That was the point of the without prejudice clause in its correspondence. How could then these negotiations have succeeded? How do you negotiate with the perspective of a favourable result when the other side obstinately refuses to admit any breach of the Convention whatsoever? And what should we say about the time frame of these counter-proposals? They didn't only concern the future, but refused all responsibilities for past wrongs. I believe that here the non-possumus and the non-volumus of the venerable Mavromatis precedent could be usefully applied. Armenia cannot be forced to negotiate about something else, an aliud. Armenia has the right to stick to the Convention of 1965. And in this respect, the sound barrier could not be broken. In summary, it's beyond dispute that the positions of the parties haven't changed on these main points since the first exchanges at the end of 2020. I draw the conclusion that the requirement of the failure of prior negotiations has indeed been met. Let us now come to those procedures expressly provided for by the Convention. Now, following your Ukraine versus Russia precedent, prior procedural conditions, Article 22, are alternative. As such, the fact that the Third Committee was not being seized by Armenia is no barrier to your jurisdiction. Finally, may Armenia object to these racial discrimination measures? Well, I can see no obstacle to that. The applicant relies on its rights under the Convention and is not acting in diplomatic protection. So the condition of exhaustion of local remedies therefore does not apply. And the fact that the people involved are of Armenian ethnic origin establishes a direct interest of the applicant. But in any event, this isn't dispositive because Armenia is also entitled to complain of the treatment meted out to these persons because the Convention opens access to the court erga omnes partes. Our current dispute is no different in this respect than in the Belgium versus Senegal case of 2012 relative to the 1984 Torture Convention. Thus, as you will have noted in reading Armenia's application, Armenia considers itself entitled to adduce the responsibility of Azerbaijan under the Convention, both as an injured state and as a non-injured state, within the meaning of Articles 42 and 48 of the 2001 Articles of the International Law Commission on International Responsibility of States. Let me underscore that Armenia is complaining of measures taken against persons of Armenian ethnic or national origin. And Armenia is not relying on these persons' formal nationality. Thus, we are not in the same factual framework as was the case Qatar versus United Arab Emirates of 2021. My conclusion is that the court has jurisdiction to entertain the Armenian application, and even more so, does the court have prima facie jurisdiction to entertain a request for provisional measures. To sum up, the legal basis on which Armenia seized you is beyond reproach, and its action is wholly admissible. In peroration, let me underscore the fact that the court should not let itself be impressed by the serpentine arguments that our opponents may perchance raise in order to attempt to muddy the tranquil waters of provisional measures. Provisional measures proceedings should not be bogged down. They have to keep their autonomy in order to be able to fill their function, which is to protect. To subject to subject this procedure to quibbles and nuances would be tantamount to adulteration and anesthesia. I'm quite sure that the court will be extremely vigilant not to let itself be dragged into the quicksand. Distinguished members of the court, this observation brings to an end my short presentation this morning. I'd like to thank you for your kind attention, Madam President. Might I ask you to call Maître Salonidis to the bar? Thank you.
I thank Professor Kolb for his statement, and I now invite Mr. Konstantinos Salonidis to take the floor. You have the floor, sir.
Madam President, distinguished members of the court, good morning. It is an honor to appear before you and the privilege to do so on behalf of the Republic of Armenia. Armenia respectfully requests that you order Azerbaijan to refrain from espousing hatred of people of Armenian ethnic or national origin, including by closing or suspending the activities of the so-called military trophies park. My task this morning is to explain the plausibility of the rights Armenia seeks to protect through this request. I will start by briefly recalling Azerbaijan's fundamental obligation under the Convention to combat racist hate speech. I will then turn to the plausibility of Armenia's rights in that regard and the evidence that sustains it. The Convention's third preambular paragraph proclaims that, quote, all human beings are entitled to equal protection of the law against any discrimination and against any incitement to discrimination. Racist hate speech was naturally an object of concern for the drafters of the third, and it has been no different for the body entrusted with monitoring its implementation. Indeed, according to the third committee, the identification and combating of hate speech practices is integral to the achievement of the objectives of the Convention. The principal vehicle for combating hate speech in the Convention is Article 4. Article 4 establishes in subparagraph C Azerbaijan's obligation to, quote, not permit public authorities or public institutions, national or local, to promote or incite racial discrimination. The obligation encompasses racist expressions emanating from public institutions or authorities, which the third committee considers as of particular concern, especially statements attributed to high-ranking officials. Other provisions in the Convention also contribute to combating racist hate speech. For example, Article 2, paragraph 1a, obligates Azerbaijan to, quote, engage in no act or practice of racial discrimination, and to ensure that all of its public authorities and institutions shall act in conformity with this obligation. For its part, Article 7 requires Azerbaijan to, quote, adopt immediate and effective measures, particularly in the fields of teaching, education, culture and information, with a view to combating prejudices which lead to racial discrimination. Armenia's request seeks to protect precisely rights arising under these provisions from a real and imminent risk of irreparable prejudice. At this stage of the proceedings, the court is not called upon to determine whether these rights definitively exist. Rather, the court need only satisfy itself that such rights are plausible under the Convention. The court has found previously the plausibility condition to be met when the asserted rights are grounded in a possible interpretation of the treaty in question. In other cases under the Convention, the court has also examined whether, quote, it is plausible that the acts complained of constitute acts of racial discrimination. Armenia's rights under Articles 2, 4, and 7 of the Convention are not just plausible. They are explicitly stated in the Convention. Instead of respecting those rights, corresponding to some of its most fundamental obligations under the Convention, Azerbaijan is flagrantly violating them on a daily basis through a constant rhetoric of hate, espoused by the highest echelons of the Azerbaijani establishment, openly and with complete impunity. The Third Committee itself has criticized the, quote, repeated and unpunished use of inflammatory language by Azerbaijani politicians speaking about the Nagorno-Karabakh conflict, and noted its adverse impact on the public's view of ethnic Armenians. Other international institutions have expressed similar concerns. The Council of Europe's Advisory Committee on the Framework Convention for the Protection of National Minorities has referred to, quote, the very persistent public narrative surrounding the Nagorno-Karabakh conflict that identifies variably Armenia and Armenians as the enemy and openly promulgates hate messages. And the European Commission Against Racism and Intolerance has noted, quote, that an entire generation of Azerbaijanis has now grown up listening to this hateful rhetoric. This rhetoric escalated before and during the September-November 2020 armed conflict. And regrettably, it was Azerbaijan's highest-ranking official, President Ilham Aliyev, who set the tone. His dehumanizing metaphors, equating Armenians to dogs, became a rallying cry during the conflict, showing, in the words of a commentator, the degree of hostility and hate speech within Azeri society. But the presidential hate speech did not stop with the end of Azerbaijan's aggression in November 2020. Month after month, it continues to this day. For example, in December 2020, President Aliyev characterized Armenians as the despised and savage enemy and as aliens to the region. In January this year, he claimed that Armenians have no moral values and cautioned his compatriots to not be likened to them. In February, he stated that Armenians cling to other countries like a leech. In March, he declared that Armenians are sick, ravaged by a virus worse than the coronavirus. In April, while proudly inaugurating the military trophies park, he suggested that savage is perhaps too soft of a word to describe Armenians. Later that same month, he called the United States government's recognition of the Armenian genocide unacceptable and a historic mistake. In May, he referred to Armenians as barbarians who destroyed and plundered the land like a wild tribe, and declared that these people cannot build a state. These people can only live within other large states. In June, he claimed that the whole world knows that the first Armenian state was established on Azerbaijan's historical land. In July, he reiterated that Armenians have no historical basis for living there, meaning Nagorno-Karabakh. In August, he found vandalism to be inherent in Armenians. In September, he once again proclaimed that Armenians have a mental illness and are a deprived and impertinent tribe. A mere 10 days ago, he stated that the Armenian nation has nothing to do with the Caucasus and that Armenians are settlers there and everyone knows where they came from. Madam President, members of the court, it is said that hate speech is in the ear of the beholder. You will read President Aliyev's speech in their entirety, and you will appreciate for yourself the context in which these statements were made. You will also discover the obvious answer. These are not a mere expression of controversial ideas or opinions. These are incitement to hatred, contempt, violence, or discrimination, plain and simple. They are the continuation of a hateful rhetoric that has been ongoing for years. The problem, of course, is not just President Aliyev's rhetoric. Anti-Armenian hate speech is by no means limited to him. The problem is that it is this official discourse that shapes the viewpoints of Armenians, of generations upon generations of Azerbaijanis. Why? Because President Aliyev's grip on Azerbaijan is absolute, and this is putting it mildly. Freedom House ranks Azerbaijan as not free and among the lowest scoring countries in terms of its citizens' civil liberties and political rights. Human Rights Watch has noted that all mainstream media are under tight government control. As a result, there is no counterpoint to anti-Armenian hate. Activists working on promoting dialogue between the Armenian and Azerbaijani societies are routinely arrested and sentenced on false charges of high treason, as the European Court of Human Rights has recently found. This discourse shapes and feeds upon an environment that openly glorifies and rewards abhorrent crimes against Armenians. The image on your screens is from a stamp proudly issued by Azerbaijan to commemorate the major events of 2020, namely its fight against the coronavirus and war of aggression against Nagorno-Karabakh. The image depicts a disinfection specialist standing over a map of Azerbaijan and fumigating an area in dark green color. That area is Nagorno-Karabakh, as well as the southern parts of Armenia. The message is clear. Ethnic Armenians are a virus in need of eradication. The references to ethnic cleansing are so blatant that the Universal Postal Union declined to register the stamp and invited Azerbaijan to withdraw it. Another notorious example of glorification of anti-Armenian hate is the case of Lieutenant Ramil Safarov. Instead of serving the life sentence he was originally given in Hungary for the brutal murder of his Armenian colleague, attending the same NATO English language course in Budapest in 2004, upon his extradition to Azerbaijan, Safarov was pardoned, promoted to the rank of major, and given a flat, and all of his wages lost since his arrest. He was labeled as an exemplary model of patriotism for the Azerbaijani youth by no less than the human rights defender of Armenia, of Azerbaijan, my apologies. Recently, the European Court of Human Rights found all these actions to be racially motivated by an animus against ethnic Armenians. The Third Committee, for its part, noted that, quote, by welcoming a citizen of Azerbaijan convicted of murdering an Armenian as a national hero, and by pardoning and releasing that person upon transfer, Azerbaijan condones racial hatred hate crimes, and denies redress to victims. In this environment of hate and glorification, is it then a surprise that the atrocious sites of the so-called military trophies park came to be? On your screens, you can see some of the racist depictions of Armenian soldiers in denigrating and dehumanizing scenes. Several European institutions deplored this park of hate, and you can find these reactions in footnote. You can also find under tab 2 of your folders the Armenian Human Rights Defenders report on the park. The images from that gruesome park alone are sufficient to establish the plausibility of Armenia's rights that this request seeks to protect. And this is so, Madam President, members of the court, notwithstanding the documents that Azerbaijan produced on the eve of this hearing. The documents in question purport to represent that the park's racist mannequins and bullet-torn helmets of Armenian soldiers were removed on the 1st and 8th of October, respectively. Mr. Martin, after me, will explain why this maneuver, even if taken at face value, cannot spare Azerbaijan from the exercise of your jurisdiction to indicate provisional measures. For my purposes, I would like to recall that a few months ago, Azerbaijan defended the park against appeals to remove its racist displays, calling it a symbol of the triumph of international law and justice, a place for education for the present and future generations, and even a venue for seeking the truth. What changed such as to force Azerbaijan to reconsider this position? President Aliyev's hateful rhetoric certainly did not change. It has been going on and on and on, and as I explained earlier. And I'm afraid that it will continue even after this hearing. No. What changed is Armenia's application instituting these proceedings and the prospect of your provisional measures. This is what has motivated Azerbaijan to represent on the eve of this hearing that it has removed some of the park's racist displays. This conduct can only underscore the plausibility of Armenia's rights under Articles 2, 4, and 7 of the Convention. Madam President, distinguished members of the Court, the Third Committee has underscored the, quote, special responsibility of public figures to provide anti-racist and pro-tolerance leadership. Yet, despite his special responsibility, rather than using his voice to combat expressions of anti-Armenian hate, President Aliyev has orchestrated a chorus of anti-Armenian hate. Like many ordinary Azerbaijanis, government institutions and other high-ranking officials have followed suit. The humanitarian consequences that my colleagues after me will address stand as a testament to this sad fact. There can be no doubt that if left unchecked, this rhetoric of hate will continue. Armenia's rights under Articles 2, 4, and 7 of the Convention meet any threshold of plausibility for purposes of this phase of the proceedings. Madam President, members of the Court, I thank you for your attention. I would kindly ask you to invite Professor Murphy to address you next.
I thank Mr. Salonides for his statement, and I now invite Professor Sean Murphy to take the floor. You have the floor, Professor.
Thank you, Madam President. It's a great honor to appear before the court and to do so on behalf of the Republic of Armenia. I will be addressing the facts relating to the inhuman and degrading treatment of and the failure to repatriate the prisoners of war and civilian detainees of Armenian ethnic origin. Thereafter, I will demonstrate the plausibility of that such conduct is a denial of rights and obligations arising under the CERD. As noted by Armenia's agent, on 27 September 2020, an international armed conflict broke out in Nagorno-Karabakh. Most of the fighting occurred over the next 44 days, at which point a ceasefire was reached on 10 November, brought about by the trilateral statement of Armenia, Azerbaijan, and Russia. Yet sporadic troop movements, encounters, and armed incidents continued thereafter, including during a period when Russian peacekeeping troops were being deployed. Azerbaijan is obligated to repatriate all POWs and protected civilians under international humanitarian law, human rights law, and the trilateral statement, which provides that the parties shall exchange prisoners of war, hostages, and other detained persons and bodies of the dead. Yet Azerbaijan continues to detain 42 Armenian POWs and 3 Armenian civilians in violation of their rights under the CERD, including to equality before the law. And to be clear, the fact that Azerbaijan is detaining these 45 individuals is not in dispute. A list of their names and other information is in your judge's folder at tab 3. These are specific people, they have names, they have faces, and they have families. The first 2 POWs are Armenian members of the Mobilization Reserve of the Armenian Army. The first of these 2, named Alosha Kosovan, was captured in early October 2020 in Artsakh. The second POW, Ludwig Mccurchin, was captured on 20 October 2020 in Fuzilay district of Artsakh. Thereafter, the list contains 38 POWs who appear as numbers 3 to 40 on the list. These POWs are Armenian soldiers captured on 13 December 2020 by Azerbaijani Special Armed Forces near the villages of Hintagir and Kurtsaberg, which are in the Hadrat region of the Republic of Artsakh. The 2 villages and surrounding territories were not among the territories from which Armenian troops were required to withdraw under the trilateral statement. Rather, this is an area where the forces of both sides were to remain at their current positions, and then along the line of contact, there was to be deployed Russian peacekeepers. As of 12 December, Russian peacekeepers had not yet fully deployed along this part of the line of contact. However, after this incident occurred on 13 December, Russian peacekeepers raced down to this area of Nagorno-Karabakh. On your screen is a Russian map dated 13 December 2020, with Armenia's translations into English. From this map, you can see the Russian peacekeeping zone, encircled by a thick blue line, which includes at the very bottom of the zone the village of Hintajr. The village of Kurtzeberd is not visible on this map, but it is less than 10 kilometers northwest from Hintajr, and hence it is also in the zone. Thus, in the aftermath of the ceasefire, and while the peacekeeping forces were being deployed along the line of contact between the two belligerents' military forces, Azerbaijan launched a military operation that captured 62 Armenian soldiers, known as the Kitzeberd Group. Of those 62 POWs, 24 have been repatriated, but 38 remain detained by Azerbaijan. Two further POWs, who appear as numbers 41 and 42 on the list, are Armenian soldiers captured on 27 May 2021. On that day, Azerbaijan surrounded and captured 6 Armenian soldiers near Kut village in the Gagarkakunik region of Armenia, where they were engaged in engineering work. Although these soldiers were not in Azerbaijan, Azerbaijan alleges that they had tried to carry out sabotage and reconnaissance operation and sabotage terrorist activities in Azerbaijan aimed at planting landmines in the roads. 4 of the 6 soldiers were part of a group of 15 POWs repatriated to Armenia on 12 June 2021. But 2 less fortunate soldiers from this same group, Ishkan Sargsyan and Vladimir Rafaelian, remain POWs. Finally, Azerbaijan has acknowledged that it continues to detain 3 Armenian civilians who appear on page 9 of your list. These civilians are protected under the 4th Geneva Convention. The first civilian, an Armenian-Lebanese dual national named Vikin Yuljekshian, was detained on 10 November 2020 by Azerbaijani armed forces while he was driving to collect personal belongings in Shushi before returning to Armenia. The other 2 civilians, named Gevorg Sezhian and David Davitin, were detained on 11 November 2020. They are employed by a non-governmental charitable organization that conducts humanitarian activities for the civilian population who are affected by the conflict. These 2 civilians were detained during a humanitarian mission while driving along the Goris-Stepanakert highway. Madam President, separate from these 45 POWs and protected civilians, there are dozens of Armenians believed to be in Azerbaijani's custody, but Azerbaijan has failed to acknowledge them, despite direct evidence of their capture. Such evidence includes testimonies of former POWs and civilian detainees, as well as videos and photographic images showing them being held captive. As far as Armenia is aware, neither their families nor the ICRC have information on their whereabouts or whether they are still alive. Efforts before the European Court of Human Rights to obtain information and release of such persons have resulted in a series of interim measure decisions of protection by that court, which inter alia called upon Azerbaijan to provide information on these individuals. But as that court noted in December 2020, the Azerbaijani government has frequently failed to provide the information requested by the court, prompting a referral of the matter in March 2021 to the Council of Europe's Committee of Ministers. Ultimately, whether the persons have been acknowledged or not, the Strasbourg Court, as a rule, does not issue interim measures ordering the release of detainees in such circumstances. Madam President, there is an overwhelming body of evidence indicating that every one of the 45 acknowledged detainees and a large number of other detainees have been subjected to torture, degrading treatment, and other abuse by Azerbaijan. Indeed, there are numerous corroborated reports by independent organizations that the POWs and civilian detainees have been exposed to stabbings, beatings, burnings, and electric shocks. Such treatment is often accompanied by ethnic slurs and other hate speech. While Azerbaijan has sought to hide such treatment, it is readily apparent from the consistent and credible reports by POWs and civilian detainees who have been allowed to return to Armenia. Members of the court, the documentary evidence is shocking enough. But there is also, among this body of evidence, a large number of videos that we have submitted to you where the court can see with its own eyes the horrific abuse. You'll find the reference pages for those videos in your judge's folder at tab 4. These videos were posted on social media by Azerbaijani servicemen or others and were then picked up by news sources. For some of these videos, we added English subtitles so that the court may understand what is being said. I anticipate that you will find these videos deeply disturbing, not only from the atrocious acts being committed, but in the clear hatred being shown to persons of Armenian origin. Tragically, it's well known that a number of military and civilian detainees of Armenian origin have not just been inhumanely treated, they've also been executed. These executions are also evidenced by witness accounts and other information. And these executions are also evidenced by videos that we've submitted to the court. Here, too, the court will find these execution videos shocking, graphic, reprehensible, and riddled with hate speech. And sadly, even in death, the abuse continues, as there are also numerous videos of the bodies of deceased Armenian soldiers being mutilated by Azerbaijani soldiers, done in conjunction with hateful slurs against the Armenian people. We urge you to review these videos as you consider the fate of the 45 acknowledged detainees and of those detainees who have not been acknowledged. But to highlight how the suffering seen in these videos directly connects to the current detainees, I wish to describe one of the videos, which is found at Armenia's Annex 69. This video demonstrates the suffering of one of the acknowledged POWs, Ludwig Mccurchin, who is the second POW listed in tab 3 of your folders. In the video, which may have been taken shortly after Mccurchin and other Armenian soldiers were taken captive, you will see Mccurchin lying on the ground along with the other POWs. Mccurchin has a bullet wound in his left hip and tailbone. Despite that wound, he is blindfolded and he is restrained. He is clearly hors de combat, yet his Azerbaijani captors kick him in the back, they step on his head, and they poke him with a sharp rod. One of his captors asks, "Where is his finger? Shall I cut it?" Mccurchin begs not to be harmed. He says, and I quote, "Don't shoot. Please, don't kill me." In the video, the other Armenian POWs fare no better with such treatment. The Azerbaijani soldiers also step on them, kick them, poke them with the sharp rod. These POWs, as you will see, are clearly afraid. One of the POWs begs not to be harmed. One of the captors responds with hateful language. He says, and I quote, "You're going to keep on begging like this a lot. You, the disgraceful people, pimps, faggots." Towards the end of the video, one of the captors says about one of the POWs, "Cut it, cut the finger." Another captor approaches that POW with a sharp metal rod. As the POW, blindfolded, bound, and prostrate, begs not to be touched, the captor then places the sharp rod against the POW's fingers and then pulls back just before the video ends. I note that the corroboration of this abuse, and specifically of Mccurchin, can be found in other videos that we have provided to the court. Members of the court, we submit that there's an ample basis for the court to conclude in this proceeding, as it did in the Tehran hostages case, that continuance of the situation, the subject of the present request, exposes the human beings concerned to privation, hardship, anguish, and even danger to life and health, and thus a serious possibility of irreparable harm. Another form of this abusive treatment bears noting. Azerbaijan has subjected these detainees to sham criminal proceedings in which individuals are charged long after they should have been repatriated and then tried and convicted in a matter of days, often in a language they do not understand. These convictions were typically based on charges that are not triable under the laws of war. For example, it makes no sense in the context of a ceasefire agreement that leaves armed forces positioned in places opposite each other for one side to charge the soldiers of the other side with illegal border crossing and illegal carrying of firearms. Likewise, it makes no sense to convict someone as a mercenary when he is a national of one of the belligerents. The two POWs captured in October 2020 were convicted for acts that allegedly occurred 3 decades ago, which at the time were never pursued by Azerbaijani authorities, and in any event were overtaken by the obligation to repatriate. Moreover, some of these convictions apparently were based on confessions, yet there is ample evidence of Azerbaijan coercing confessions through torture. The court simply cannot countenance a justification for detaining POWs and civilians that is tainted by such conduct. That these criminal proceedings are a sham is also demonstrated by the fact that Azerbaijan blithely releases some of these so-called criminals whenever it is able to extract something from Armenia in exchange. As I previously noted, 6 POWs were captured on May 27th of this year. Azerbaijan rushed to charge them with crimes on 28 and 29 May. Then, just 2 weeks later, on 12 June, 4 of those POWs were released as part of a group of 15 Armenian POWs. Why release POWs who are allegedly criminals? Well, they were released by Azerbaijan so long as Armenia provided a map detailing the location of mines in Agdam. Such conduct is arbitrary, and it speaks volumes about the nature of Azerbaijan's so-called criminal proceedings. Indeed, similarly, Azerbaijan charged a group of Armenian POWs with the crime of illegally crossing the border, and on 2 July 2021, sentenced them to prison. Yet the very next day, on 3 July, Azerbaijan released 12 of them as part of a group of 15 POWs, this time in exchange for maps of mines in the Fuzulay and Zangala regions. The 3 others in this group still had their trials pending, yet they too were repatriated. The arbitrariness of Azerbaijan's so-called criminal proceedings continues in that all 15 of those released POWs were from the Kurtzabird group, yet many others from that same group remain detained. Hence, the fact that the continued detention of the POWs has nothing to do with actual criminality is readily apparent from Azerbaijan's willingness to repatriate some POWs on some occasions whenever Azerbaijan believes it has extracted something from Armenia, while refusing to repatriate other POWs who were captured for the same acts and at the same time and in the same place. This is not a situation of applying criminal law fairly and judiciously. It's using criminal law arbitrarily as a subterfuge for prohibited discriminatory conduct. Finally, on the factual discussion, while it's reported that Azerbaijan is allowing the ICRC to visit these 45 detainees, there is also evidence that Azerbaijan is seeking to hide the other detainees and to hide its abuse of all the detainees from the ICRC and from others, making their repatriation all the more urgent. For example, the rapporteur for the Parliamentary Assembly of the Council of Europe was repeatedly denied permission to visit these detainees. I turn now to the plausibility of the rights at issue. Azerbaijan has an obligation to repatriate the POWs. Indeed, this is one of the most important obligations of international humanitarian law. Azerbaijan's disregard of that obligation is ethnic discrimination, pure and simple. Whereas virtually every other country in the world takes quite seriously the general obligation to repatriate all POWs after the cessation of hostility, Azerbaijan has not, because of its policy of hatred toward persons of Armenian ethnicity. As was apparent from the presentation of Mr. Salonides, persons of Armenian ethnicity are viewed by the Azerbaijan government as subhuman, as meriting a disgraceful and demeaning trophy park, but as not meriting the fundamental right of repatriation. For Azerbaijan, the POW's value is not to be found in human dignity. Rather, their value is as a bargaining chip. They are pawns for Azerbaijan to advance its political interests, an especially pernicious exercise of ethnic discrimination. Article 1, paragraph 1 of the CERD defines racial discrimination in broad terms to include any distinction, exclusion, restriction, or preference based on race, color, descent, or national ethnic origin. Thus, restrictions based on ethnic origin are a form of racial discrimination. Article 2 then obligates states parties not to engage in any act or practice of racial discrimination against persons or groups of persons. Article 5 furthers the fundamental obligations set out in Article 2 by making clear that, and I quote, states parties undertake to prohibit and eliminate racial discrimination in all its forms and to guarantee the right to everyone without distinction as to ethnic origin to equality before the law. Equality before the law. Moreover, Article 5, subparagraph D2 specifically protects the right to leave any country and to return to one's country. We submit that it is much more than just plausible that these rights under the CERD are being denied to the POWs. The government of Azerbaijan has directly ordered their continued detention. There's no issue of private action here. This failure to repatriate is a denial to persons of Armenian origin of their rights under the CERD to equality before the law. In this instance, before or under international humanitarian law. Azerbaijan may not, under the Third Geneva Convention, refuse to repatriate these POWs. Many organizations and observers have already reached that conclusion on the merits. Indeed, the Third Geneva Convention itself prohibits racial discrimination against POWs. When one considers the general background of Azerbaijan's hateful views regarding persons of Armenian origin, along with the inhuman and degrading treatment of these POWs, and along with the occasional use of the POWs as bargaining chips, All such circumstances strongly demonstrate that this failure to repatriate is not just plausibly racial discrimination, it is racial discrimination in the form of a denial of equality under international humanitarian law. Now, you may hear from Azerbaijan this afternoon that all these POWs are criminals and that their detention has nothing to do with ethnic discrimination. Yet all the evidence points towards ethnic discrimination, and no one is accepting Azerbaijan's claim of criminality. UN human rights experts don't accept it. The European Parliament does not accept it. The Parliamentary Assembly of the Council of Europe and its rapporteur do not accept it. Rather, all of them have called for the expeditious repatriation of these POWs, as have many governments. Time does not allow me to describe in depth the plausibility of the POW's rights under the CERD not to be beaten, tortured, or otherwise physically or mentally abused. But here, too, we submit that it is much more than just plausible that such treatment violates CERD Articles 2 and 5, and in particular Article 5, subparagraph B, which protects the right to security of person and protection by the states against violence or bodily harm. The POW's treatment before Azerbaijani courts also clearly implicates CERD Article 5, subparagraph A, which recognizes the right of equal treatment before the tribunals and all other organs administering justice. And the overarching Article 5 right to equality before the law is further implicated given that Azerbaijan's inhuman and degrading treatment is a denial to an ethnic group of their rights under international humanitarian law and also under international human rights law, including prohibitions on arbitrary detention, on torture, on inhuman and degrading treatment, and as well as the freedom to leave any country and the right to a fair trial. As is the case with the POWs, it is more than plausible to maintain that the government of Azerbaijan's refusal to repatriate the 3 acknowledged civilians is a denial to persons of Armenian origin of their rights under CERD Articles 2 and 5 to equality under the law, including the security of their person and to the right to return to their country. And with respect to the equality under the law, Azerbaijan simply has no basis under either the 4th Geneva Convention or human rights law to refuse to repatriate these civilians or to treat them inhumanely. Again, many organizations and observers have already reached that conclusion on the merits. Under the 4th Geneva Convention, civilians are protected persons. And if interned during the conflict, they must be released after the cessation of hostilities. They must be treated humanely, without any distinction founded on race. They must be protected from murder, torture, or brutality. The taking of civilians as hostages is forbidden, and they shall not be deprived of the rights of a fair and regular trial as prescribed by the Convention. And similar protections for these civilians arise under the previously noted human rights law. Madam President, the plausibility of the rights claimed under the CERD with respect to POWs and civilians that Azerbaijan has not acknowledged, but has also treated inhumanely and has not repatriated, also flows from what I just said. Although these persons are not acknowledged by Azerbaijan, there is ample evidence that they were taken into captivity, that they have been abused, and obviously that they have not yet been repatriated. For the reasons previously indicated, it is more than plausible to regard their treatment as a denial to persons of Armenian origin of their rights under Articles 2 and 5 of the CERD, notably their rights to equality under the law, to return to their country, and to the security of their person. Madam President, that concludes my presentation. I ask that you now call on Professor Dargent.
I thank Professor Murphy for his statement, and I now invite Professor Pierre Dargent to take the floor. You have the floor, Professor.
Thank you, Madam President. Madam President, distinguished members of the Court, it's always an honor to speak before you, and a particular honor to do so today in the present circumstances to support Armenia. My presentation will be devoted to the necessity to protect the right of Armenia and Armenians to enjoy, without prohibited discrimination, their cultural and religious heritage. Article 2 of the Convention on the Elimination of All Forms of Racial Discrimination obliges the states parties to recall, and I quote, to engage in no act or practice of racial discrimination. Furthermore, Article 5 of the Convention imposes that one ensure without prohibited discrimination the enjoyment of the rights stated under it. Amongst those rights is the right to freedom of religion, and I quote, also the right to equal participation in cultural activities. It cannot be denied that the right to freedom of religion includes the right to practice one's religion in habitual places of worship, and thus the right to see these places respected and preserved. Likewise, the right to participate in cultural activities implies that the heritage serving the purposes of such activities be respected and preserved. And furthermore, of course, many places of worship are part of the cultural heritage. Thus, the religious and cultural heritage is likely to be protected under the Convention when it is established that it is attacked for a ground forbidden by it. The rights that Armenia asks you to protect in matters cultural, not only are they plausible ratione materiae in the light of the Convention, but also, and I will come to this, with regards to the facts. On the 8th of October 2020, Madam President, the Holy Saviour Cathedral in Shushi was twice bombed. The first attack took place around 12 o'clock, the second around 5 p.m., whereas there was no combat or other bombardments around that place on that day. These are well-documented facts, and following an inquiry undertaken in situ, Human Rights Watch concluded that the cathedral had indeed been intentionally bombed by two well-targeted volleys, and everything could lead one to think that these attacks were perpetrated by Azerbaijan that was besieging the city. To date, the defendant has not adduced any other credible explanation about these acts. The Cathedral of Shushi was coldly and deliberately pounded twice on the same day, so that the deadly message thus sent be perfectly clear. The Armenians do not have any place in Nagorno-Karabakh and will never be in security there, not even in their most sacred spaces. The bombing of the cathedral in reality was just a warlike prelude of a policy that was to manifest itself immediately after the ceasefire and extend till today. Madam President, evidence of cultural destruction that I shall adduce are numerous indeed. Armenia's application with regards to this contains many references to available documents on the Internet. Some have been reproduced in our annexes. With the corroboration of photos or videos, this evidence appeared in the media and social networks. Tallying with each other, this evidence was collected and checked by satellite images through Caucasus Heritage Watch. a research initiative undertaken by archaeologists from the universities of Cornell and Purdue in the United States. The complete reports of these archaeologists are to be found in your hearing file, tabs 13 and 14. A few days after the 10th of November, the cathedral was yet again the subject of racist attacks, during which its walls were daubed with graffiti, whereas the statues of angels ornamenting the railings surrounding the cathedral were deliberately damaged before they disappeared. Since then, Azerbaijan has undertaken what it calls restoration of the cathedral work. It removed the spire on top of the choir tower so as to return it to its original architectural so-called style and to return to the historical image of the town. But let's look at this more closely. Built between 1868 and 1887, when the region was part of the Russian Empire, here is the cathedral now on screen as it originally appeared, with its spire before the anti-Armenian pogroms of March 1920. Following the ethnical recomposition of the city caused through these dramatic events, the spire of the cathedral was removed and the religious building ceased to be maintained during the Soviet period. The cathedral resumed its original aspect in 1998 before it was bombed on the 8th of October 2020. Since then, Azerbaijan claims that restoring the cathedral could be done by removing its spire. Distinguished members of the court, in decapitating Sushi Cathedral, Azerbaijan intends to make it visible as from Stepanakert and reestablish the situation in which it was abandoned following the pogroms of 1920. And thus, indirectly, it recalls this memory. Claiming to reestablish the historical image of the city, Azerbaijan indeed reveals its policy of racial discrimination after having voluntarily destroyed the cultural heritage, the Armenian cultural heritage, by bombing it. Azerbaijan is altering, modifying what remains of it in order to diminish its presence. Through a letter of last Friday, transmitted less than 2 days ago, the Azerbaijan Vice Minister of Culture affirms that the work of restoration was undertaken in consultation with international experts. However, this internal letter in the government of the defendant doesn't prove anything unless it be its depravity. It's this letter, which you are asked to keep confidential, although it concerns a monument, manifestly was written and very cautiously formulated, framed for the purposes of the present case. And as you'll note, it's addressed to the person who's the agent of Azerbaijan in the cases submitted to your scrutiny. Furthermore, this letter states that experts would be consulted without actually naming them, nor saying anything about their visits or reports. And above all, it does not, this letter, indicate that Azerbaijan intends to rebuild the spire of the cathedral that its double bombing did not, however, succeed in striking down. The official position of the defendant is thus that the cathedral, in its original form, was without a spire, as you saw. And as you can see it again on screen, nothing could be further from historical truth. Still in Shushi, the Armenian Church of St. John the Baptist, also called the Green Chapel, was decapitated after the trilateral ceasefire declaration. In the village of Merkavan, which the defendant calls Jebrail, the BBC reported about the complete destruction of the church after it was vandalized by Azerbaijani soldiers. On the 27th of March of that year, Azerbaijani soldiers, through mockery, profaned the church of St. Yegishe in the village of Matagis, as you can see looking at the video under tab 5 in your hearing file. Very soon after the declaration of the 10th of November, Azerbaijani soldiers also went to Armenian cemeteries to cast down tombs, smash them and profanate them. Such incidents were reported on the 26th of November 2020, and then when spring came back in May 2021, in 5 places at least. In Aravot, north of Shushi, at Metztacher, at Taravard, at Shekhnach, where the old Armenian cemetery that went back to the 18th century was totally razed. Evidence of such destruction are taken up in your hearing file, tabs 6 to 10. The destructive fury of Azerbaijan also covered kachkars, a characteristic of religious art in Armenia, whose origins go back to the 4th century. A kachkar is literally a stone with a cross, either a stele about 1.50 meters high, rectangular in shape, carved in low relief with one or several crosses, surrounded by ornamental decoration of human figures or inscriptions in Armenian. And since 2010, the kachkars, Armenian kachkars, are on the list representing the immaterial cultural heritage of humanity. In Shushi, the kachkar of the bombed cathedral was then disfigured and destroyed at the late April this year. Furthermore, in territories that Azerbaijan claims to have liberated, kachkars are torn down. This was the case notably on the 12th of January 2021 in Arakel, where the Azerbaijani armed forces knocked down a kachkar through a military truck, as you can see in tab 11 in your hearing file. The cemetery at the north of Sushi, which was very considerably destroyed, had 2 kachkars of the 12th and 13th centuries. Madam President, distinguished members of the court, such a gratuitous and discriminatory destruction seeks to erase the Armenian cultural presence in Nagorno-Karabakh. Further destruction is directed against Armenian memory. At late March this year, in Shushi, Azerbaijan destroyed the monument commemorating the genocide of Armenians perpetrated by the Ottoman Empire, which is to the left on your screen. Denying the existence of genocide, the defendant considers no doubt to be entitled to destroy this monument because it commemorates an event that, according to it, did not occur. To the right of the screen, you can see the location of the monument without the monument and without inscriptions in Armenian on its surrounding wall. This photograph was taken during the presidential visit in June 2021. A flagpole, as you can see, with the flag of Azerbaijan has replaced the monument to the Armenian genocide. There could be no stronger symbol. President Aliyev making of the rewriting of history a central point in his ethno-nationalistic and discriminatory policy. Distinguished members of the court, there is no place, no room in the territories controlled by Azerbaijan for what makes and symbolizes Armenian identity. Madam President, during his speech before the General Assembly on the 23rd of September last week, thus after your court was seized by Armenia, and on the very day Azerbaijan filed in reply its own case introducing proceedings, President Aliyev on that date said this in his discourse to the General Assembly. In Azerbaijan, we cherish and support multiculturalism as a way of life. Azerbaijan is considered as an example of tolerance and peaceful coexistence of representatives of various religious and ethnic groups living in our country. End of quote. No doubt, that your season prompted the defendant to present himself before you under the most flattering light. However, such official discourses of tolerance and inclusion, as well as the very recent exhibits established for the purposes of the present case, obviously sound hollow when they are confronted, as they should be and must be, when they are confronted with the reality of the facts that my colleagues and myself have just related. Beyond the window-dressing speeches, these facts reveal the genuine nature of the Azerbaijani political regime and its hateful practices contrary to the convention. Madam President, distinguished members of the court, the official discourse of Azerbaijan is all the more misleading, and the destructions of the Armenian heritage in Nagorno-Karabakh are all the more foreseeable since they occur in a particularly worrisome context. And apropos of this, I should like to propose 5 indisputable contextual elements. On the one hand, and you will have noted this through the chronology of the events, Azerbaijan undertook the cultural destruction and other breaches reported by my colleagues. At the time, it was engaged in negotiations started by Armenia pursuant to Article 22 of the Convention. Baku many a time declared to undertake these negotiations in good faith, though all the while accusing Armenia of not doing so. The duplicity of the defendant will not have escaped your attention. Furthermore, another flagrant case of duplicity, the official discourse of the defendant destined to chancelleries is very different from that aimed at its national public opinion. As Mr. Salonidis recalled, 4 days hardly after his speech before the General Assembly, President Aliyev addressed himself to his people by stoking anti-Armenian hatred, using very discriminatory and shocking terms. Furthermore, a third contextual element which is particularly worrisome, the destructions and profanations in Nagorno-Karabakh were and are still perpetrated in camera. UNESCO has still not been able to access the Armenian cultural sites, whereas the Deputy Director General of the organization on the 21st of December declared in 2020 only the response of Azerbaijan is still awaited for UNESCO to proceed with the sending of a mission to the field. End of quote. On the occasion of his New Year's message, in other words, 10 days after the solemn appeal of UNESCO, President Aliyev accused the international organization of lying and practicing a policy of double standards. And we know, too, since less than 2 days, we know that in August this year, Azerbaijan set aside a visit of UNESCO once again because notably its terms of reference mention Nagorno-Karabakh, an appellation which is henceforth rejected by the defendant, whereas the trilateral declaration of the 10th of November, which is binding upon it, uses that expression no less than 5 times in 9 paragraphs. So then, distinguished members of the court, that is the state of mind in which the defendants tackle the question of preservation of cultural heritage. It uses this to push its political agenda and force the hand of the international organization. And then the fourth element, contextual element that need be recalled, is due to the fact that Azerbaijan, alas, is accustomed with cultural destruction when it's a matter of attacking the Armenian historical heritage in the Autonomous Republic of Nakhichevan, located in the southwest of Armenia. Azerbaijan has committed innumerable cultural destructions since its independence, especially in 2005. Baku raised literally the old cemetery in Jura, which had thousands khachkars, the greatest, the largest collection in the world. These facts and others were duly documented, and we will return to them when we come to the merits of the present case. The International Council for Monuments and Sites, as well as the European Parliament, deplored and denounced what the press qualified as the worst cultural genocide of the 21st century, to quote it. Now, when faced with legitimate such condemnations, the reply of the authorities in Baku was to try to attempt to change reality. So, from historical revisionism to negationism, there is indeed only one step that Azerbaijan blithely takes through the voice of its ambassador in London, whom I quote. First and foremost, we need to make it clear that there is no such thing as Armenian heritage in the Nakhchivan Autonomous Republic, simply because Armenians never lived there. Non-existing sites or cemeteries cannot be destroyed. And finally, and this is the fifth contextual element to reinforce the need to urgently to protect the Armenian heritage. Well, finally, Baku deploys the same historical revisionism with regards to Nagorno-Karabakh. Indeed, the destructions and profanations upon religious and cultural Armenian sites is accompanied with an official discourse seeking to make one believe that the Armenian heritage of Nagorno-Karabakh was a usurped heritage because the Armenian churches are monuments that belong to the Udi people, an Albanian Caucasian people whose trace we find in antiquity, and that the propaganda of Baku considers as being proto-Azerbaijani. Posing in camouflage outfit before the church of St. Asvastatsim in the village of Tsakuri. In March 2021, President Aliyev launched him into a diatribe propagating such a theory, claiming that the church was a former Albanian church upon which Armenian inscriptions would have been placed at a later date. The internet site of the presidency translated the speech of the head of state on video and film, and this is accessible on YouTube, tab 22 of your file. So, changing historical narrative in order to justify such cultural destructions and to lessen the century-old presence of Armenia in Nagorno-Karabakh, Azerbaijan is also changing its administrative language. Referring to two of its recent decrees, President Aliyev declared during his speech of the 23rd of September last before the General Assembly, he stated that, and I quote, "There is no administrative territorial unit called Nagorno-Karabakh in Azerbaijan." Distinguished members of the court, what this apparently anodyne change, since it's a bureaucratic change, and what it conceals is basically the discriminatory, destructive and revisionist attitude of Baku with regards to authentic testimony of centuries-old Armenian presence in the territories under its control, that is to say, Armenian churches, Armenian cemeteries, khachkars, and all monuments recalling such a presence. The conduct of Azerbaijan is manifestly contrary to Articles 2 and 5 of the Convention, because it is clear that the sole and unique reason for which Azerbaijan is striving as it does with regards to Armenian cultural heritage is precisely because it is Armenian. Distinguished members of the court, I would like to thank you for your kind attention. May I ask you, Madam President, to call upon Mr. Larry Martin to the bar.
I thank Professor Darjan for his statement, and I now invite Mr. Larry Martin to take the floor. You have the floor, Mr. Martin.
Madam President, distinguished members of the court, good morning. It is an honor and a privilege to appear before you on behalf of Armenia. It falls to me today to address the issues of urgency and irreparability, and of the link between the rights for which Armenia seeks protection and the provisional measures we request. Fortunately, I can be brief. Nothing about what I'm about to say should be controversial. In fact, it all flows directly, inescapably, from my colleagues' presentations before me. The urgent need to protect Armenians from continued hate speech, to repatriate and protect Armenian POWs and detainees from further mistreatment, and to protect Armenian cultural heritage from erasure, all follows from the evidence as unavoidably as night follows day. The court has made clear that it will exercise its power to indicate provisional measures, quote, only if there is urgency, in the sense that there is a real and imminent risk that irreparable prejudice will be caused before the court gives its final decision, end quote. That condition is met, quote, when the acts susceptible of causing irreparable prejudice can occur at any moment before the court makes a final decision on the case. To be sure, not just any irreparable prejudice counts. What matters is that, quote, irreparable prejudice could be caused to the rights which are the subject of judicial proceedings, or the alleged disregard of such rights may entail irreparable consequences. At this preliminary stage of proceedings, the court is not required to, quote, make definitive findings of fact, or determine that cert has, in fact, been violated. To the contrary, the court need only determine that it is, quote, not inconceivable that a violation might occur, or that information before the court, quote, does not exclude the possibility that irreparable harm might be caused. All of these elements are plainly present here. On the issue of hate speech, as Dr. Salaniadis showed, Armenians have the right under CERD to be free of racial discrimination by Azerbaijan in all its forms, including racist hate speech. CERD specifically requires Azerbaijan, quote, not to permit public authorities or public institutions, national or local, to promote or incite racial discrimination. Yet, even so, President Aliyev, who inherited the job from his father and has held the highest office in the land for 18 years, continues to spew racist hatred to this day. As recently as last month, he said Armenians have, quote, a mental illness, and called them worse than animals and a, quote, depraved tribe. How does such hate speech threaten irreparable harm? Simple. Hate begets hate. And hate emanating from a state's highest authority begets more hate still. Dr. Salaniadis recalled that the CERD committee has observed that, quote, racist expressions emanating from public authorities or institutions are of particular concern, especially statements attributed to high-ranking officials. As some of us have learned from our own recent national experience, hatred from the top, even in a nominally free country, operates as a kind of license that opens the floodgates, allowing other elements of society to follow suit. The obsessive and continuing expressions of hatred for Armenians coming from President Aliyev and other senior government officials thus constitute a disregard for the rights of Armenians that may easily entail irreparable consequences. They fan the flames of open racism that immediately imperil the rights of all Armenians, including those living in Nagorno-Karabakh and those still held in captivity. Indeed, such speech places them in even greater physical jeopardy than they already are. By actively fomenting an atmosphere of hate, President Aliyev and other senior government officials are making their physical and mental abuse even more likely. The ghoulish military trophies park is a perfect demonstration of the point. Open 6 days a week to anyone over the age of 6. The displays at the park teach Azeris young and old, but it is not only permissible, but actually desirable to mock, degrade, and abuse Armenians. The park serves as an obvious signal that such mistreatment is condoned at the highest levels. Does anyone really think that the Azerbaijani soldiers responsible for guarding Armenian POWs and civilian detainees will miss the message? In short, the park badly exacerbates the already real and present threat to the detainees. Late Tuesday, less than 48 hours ago, Azerbaijan submitted an unsworn and strangely confidential document stating that the mannequins had allegedly been removed from the park, albeit 2 weeks after Armenia filed its request. And last night, it submitted yet another unsworn, confidential document claiming that the bullet-torn helmets had also been removed another week after that. Even accepting this extraordinarily belated evidence is properly before the court and can be credited, which we do not accept. None of it affects the urgency of the need to order the park closed. In the first place, some images of the mannequins from President Aliyev's visit remain on the park's website, as you can see now. In the absence of a formal public undertaking made by Azerbaijan's agent before this court, there is no guarantee they will not be returned the moment these hearings are over. Even then, the park remains as a conspicuous symbol of hate, a celebration of Armenia's defeat. What other message could it possibly convey? The urgent threat of irreparable prejudice resulting from Azerbaijan's continuing wrongful detention of Armenian nationals is more obvious still. Professor Murphy explained that the rights in dispute in this case include the right of Armenian POWs and civilian detainees to the equal enjoyment of their individual rights, including, but not limited to, repatriation and the right to security of person and protection by the state against violence or bodily harm. Unlawful detention is inherently a form of irreparable prejudice. Those detained for months or years before you reach a decision on the merits in this case will never get that time back. This is not an exaggeration. As Professor Murphy explained, Azerbaijan has already sentenced many of the detainees to serve years in Azerbaijani prisons. The only way to avoid such irreparable harm is a provisional measure from the court ordering repatriation. Professor Murphy also explained that the evidence shows a clear record and practice of Azerbaijani authorities abusing Armenian detainees, soldiers and civilians alike. The gruesome videos that Armenia has presented to the court will haunt the nightmares of those of us who have watched them for a very long time. Given the lengthy prison sentences that Azerbaijan has issued, there is no doubt that the detainees are extremely vulnerable for an extended period of time to continued abuse by Azerbaijani guards. the need for the urgent intervention of this court to prevent further irreversible harm is almost too obvious to say. If the clear and present threat of imminent psychological trauma, bodily harm, and even death does not warrant the indication of provisional measures, it would be hard to imagine what would. Indeed, the court has repeatedly found the requirements of urgency and irreparability met in situations where there were serious threats to human life and safety. In Georgia v. Russia, the court indicated provisional measures where, quote, violations of the right to security of persons and the right to protection by the state against violence or bodily harm could, quote, involve potential loss of life and bodily injury. Also relevant was the fact that the circumstances were, as they are here, quote, unstable and could rapidly change due to, quote, ongoing tension in the absence of an overall settlement to the conflict. And of course, in the hostages case, the court ordered the, quote, immediate release without any exception of all persons of United States nationality who had been held hostage. It did so in light of, quote, the privation, hardship, anguish, and even danger to life and health to which they were exposed. These are just examples, but they are enough to show that the court has long recognized that protecting individuals from harm is the quintessential circumstance warranting the indication of provisional measures. Armenia respectfully suggests that the court should do exactly that here to protect the remaining detainees in Azerbaijani custody. The urgent need for interim measures to protect Armenian cultural heritage is equally clear. Professor Darjan showed that Armenia's rights in dispute include the right to access and enjoy cultural heritage. That right includes the right to have that heritage protected, not destroyed, vandalized, or have its character altered. Yet, as Professor Darjan also showed, that is exactly what Azerbaijan is doing in conducting an ongoing campaign to erase the evidence of Armenia's presence from its territory. Just by way of example, revolting as it is, satellite photos make clear that between 12 April and 18 June 2021, a historic Armenian cemetery in the village of Sekhach was razed to make way for the construction of a road. Azerbaijan is literally paving over Armenian history. The risk here is real and ongoing for the reasons Professor Darjan explained. But the extent of the risk also cannot be understood without some mention of the historical context. As set out in our application and request for provisional measures, the relationship between Armenia and Azerbaijan has long been complicated, to say the least. As also set out in our application, even before the most recent armed conflict, Azerbaijan was prolific in its effort to erase any vestige of the Armenian presence from its territory. We refer to a number of examples in footnote. The continued spewing of racist hate speech by President Aliyev and other senior officials only exacerbates this real and present risk. Indeed, by refusing even to acknowledge the existence of Armenian cultural heritage, President Aliyev is directly promoting a climate that is even more conducive to the hate-filled destruction of that heritage. In concluding on this point, I note that the court has, in the past, ordered provisional measures to protect property and other tangible items from destruction. In the recent Cambodia v. Thailand case, it ordered measures to ensure that, quote, no irreparable damage is caused to property, including a UNESCO World Heritage Site. And in DRC v. Uganda, it did so in circumstances where, quote, assets and resources in the area of conflict remained vulnerable. We respectfully submit that the court should follow these examples and similarly order provisional measures to protect Armenia's cultural heritage from the very real and very urgent risk of irreparable prejudice. That brings me, Madam President, to the second and last part of my presentation this morning, the requirement that the provisional measures we seek be linked to the rights whose protection we seek. On this subject, I can be even more brief. The requisite link between the relevant rights and measures is even more obvious than is the urgent threat of irreparable harm. I will not burden the court by reciting the full text of the provisional measures we request. They are set out in our request, and the distinguished agent will return to them at the end of tomorrow's session. Suffice it now to note that they fall into four broad categories that precisely dovetail with the rights whose protection we seek. The first category of measures we request relates to the Armenian POWs and other detainees. To put it simply, we ask the court to order Azerbaijan to release them, and pending that, to treat them humanely. As Professor Murphy explained, and I underscored a few moments ago, the rights whose protection we seek include, among others, the rights of the detainees under Article 2 to be free of racial discrimination in all of its forms, and under Article 5 to be secure in their person and to be protected by the state from violence and bodily harm. As in the hostages case, the only genuine way to protect that right is to order the detainees' immediate release. The widely confirmed reports of Armenian detainees being tortured and even executed in captivity, and Azerbaijan's wholesale denial of the same leaves no other option. Requesting that they be treated humanely in the interim is asking nothing more than that the rights in dispute be respected. The second category of measures we request relate to the hate speech coming from the very top of the Azerbaijani government in the disturbing military trophies park. In short, we ask the court order that the hate speech be stopped and the park closed. Those measures are directly linked to Armenia's rights under Articles 2, 4, and 7 of CERD. The third category of measures relates to the protection of cultural heritage. We ask that the court order Azerbaijan to protect Armenians' right under Article 5 to equal participation in cultural activities, including the right of access to and enjoyment of their cultural heritage, and to take measures to stop its destruction, vandalization, and alteration. The connection between those requests and the rights to enjoy one's cultural heritage, as outlined by Professor Darjan, is, again, almost too obvious to state. The fourth category of measures we request is more general. We ask that the court order Azerbaijan, 1, to take measures to protect relevant evidence, 2, take no action that will aggravate or extend this dispute, and 3, submit regular reports on the steps it has taken to comply with the court's ultimate order. The first of these, the order to preserve evidence, is linked to the rights whose protection is sought in the sense that it is necessary to ensure that Armenia has a full and fair opportunity to present its case that Azerbaijan has violated those very rights. Without it, there is a genuine risk that Armenia's ability to vindicate those rights will be compromised. All the more since Azerbaijan has control of most of the first-hand evidence. The second and third of these general requests are largely de rigueur in circumstances like these. An order not to aggravate or extend the dispute is entirely customary. And an order for regular reporting is essential to ensure that Azerbaijan is genuinely implementing the court's order and respecting the rights of Armenians that are the subject of that order and our request. Madam President, for all these reasons, there is a very urgent risk of irreparable prejudice warranting the court's exercise of its extraordinary power to indicate provisional measures. The measures we seek, moreover, are linked to the very same rights whose protection we seek. Thank you for your kind and patient attention. That concludes Armenia's first round presentations this morning.
I thank Mr. Martin, whose statement brings to an end the first round of oral argument of Armenia, as well as this morning's sitting. The court will meet again this afternoon at 4 p.m. to hear the first round of oral argument of Azerbaijan. The sitting is adjourned.